Welcome. This is episode 2 of Ethical and Other Issues in Lateral Attorney Movements. You're looking at slide 6 now, which is a little bit of a summary of the series, and slide 7 here is just a little bit of an overview of, well, a little bit more of an overview. I am going to dispense with going through a lot of the housekeeping on this webinar because this is part 2 of a 3-part series. And if you, I would urge you to watch part 1 first, and that has all the housekeeping. The one thing I will say is I will thank our panel, Dan Binstock, Alex Edelman, Brock Nave, and Tina Solis for being here. 3 of these good people are legal recruiters, 2 of whom are non-practicing attorneys, and the 4th, Tina, is an attorney who devotes a substantial part of her practice to advising attorneys who are making a lateral move. She advised me, so how bad could she be? Um, our names are listed on slide 5, and if you go to all the way to slide 86, you can see little summaries of us. We don't go through the summaries of our bios because that's boring, and that's not what you're here for. But we trust that if one of us impresses you, you'll want to look us up. So with that said, I'm gonna dive right into the questions that I've prepared for this panel. They don't know what the questions are. That keeps things spicy and sassy. Um, I'm gonna turn, and this is what I'm gonna do throughout the webinar. When I can, I'll enunciate the slide number or numbers that I think my question relates to. I'll turn to that into the panel answer. So Brock, this first question is to you, and it is, what should attorneys be watching for in firm notice period provisions, and how do these intersect with ABA Rule 5.6? Audience slides 18, 83, and 45 to 50. That's a lot. I'll skip to each of them as Brock answers the question.
Thanks, Jonathan. So a notice provision in the partnership agreement sets out the terms under which an attorney must follow to withdraw from the partnership. I think the most important piece of the notice provision, and what we certainly spend the most time talking about, is the notice period. And you typically in the US will see anywhere from like 30 to 90 days in that notice period. And then the ABA rules, of course, prohibit restrictions on the practice of law, non-competes, et cetera. So there really, I think, is a tension these days in the specific provisions and partnership agreements with where the ABA is coming out on this. Definitely, Tina, want to hear from you because I know you've kind of been at the forefront of this. More and more, I think that with the right ethics counsel, I'm seeing partners who are being able to get a release from the partnership in a shorter period of time than the notice provision provides for, and often in a shorter period of time than their firm would like to release them. So really, when reviewing these provisions, would certainly encourage folks to get ethics counsel involved early on. You need to make sure that you're aware of the timing considerations and that you are properly giving notice as specified in the partnership agreement, and then, of course, complying with your other ethical obligations as you move forward.
And Brock, I think you're right. I think there is a little bit of a tension there. And what Model Rule 5.6 really says is no attorney should enter into an agreement that restricts his or her right to practice. And that's premised on the fact that under our system here in the US, a client always has the right to choose his or her or its counsel. And to the extent that there is a lengthy notice period, you are in, and a firm tries to enforce that, you are thereby indirectly impacting a client and its right to choose his or her counsel, because that counsel is effectively being held at that firm, and the client very much may want his or her counsel to move to the new firm. So I think Brock hit on all the highlighted points, but I do think that it is something to keep in mind. I would also encourage anyone, in the audience, take a look at ABA Formal Opinion 489 that talks about some of that tension and sort of the shifting of the burdens once transitional tasks are completed. It sort of shifts to the burden to the firm to then prove why that attorney should not be released before the end of those notice periods. I don't think it's any longer the situation where simply because the agreement says that it's 30 days or 60 days or 90 days, that's automatically what's enforced. So just my 2 cents.
Thanks, Tina. Any overlay panel? Let me switch directions. I'm going to turn us to slides 35 and 36. And Tina, you did such a good job. We'll reward you with this next question. What should attorneys consider when evaluating capital contribution policies at both their current and their prospective firms?
So I think this is a question that at first blush seems easy, but you really have to drill down and think about it, because you have to think about both sides. Not only what are the terms at your current firm regarding the repayment of any capital contributions, when is it paid back? Is it paid back in a lump sum, or is it paid out in installments? And how far are those installments stretched out? And then you have to compare the timing at your current firm regarding the return against the firm or firms that you're currently interviewing at and looking to potentially join. And there you need to look at some of the same questions, right? Is this a situation where the firm wants 100% of it to be paid in within X period of you joining? Is this a situation where the firm may allow you to pay in over time? Is this a situation where the firm basically allows you to self-fund at the end of a fiscal year, such that maybe you don't have to put up any money when you accept the offer, and you can wait to start funding until the end of that first fiscal year that you're there? So, this is something that is very important, not only in terms of making sure that you're balancing what you're leaving to what you're going to for cash flow purposes, but obviously something to think about for personal cash flow interests. And, another option that you should ask if you're considering a move and in the interview process, and I'd be very interested to hear from our other panelists in terms of how best to address this with the firms that candidates are interviewing with, but does the firm offer any special terms with any pre-approved lenders? I think most firms do that these days, and I think the rates can be pretty competitive, and that certainly can ease the financial burden on a candidate who is considering a move. When that should be raised with the firms, I leave to the other experts on this panel to address, but those are just some of the things that I think should be crossing a candidate's mind if they're considering a lateral move.
Does anyone have a view based on their experience of how common it is that capital a buy-in is all at once at the beginning? Because my general impression is that's actually more of an assumption. It's not happened to me in the past, but and I guess for that reason I assumed it would be the exception rather than the rule. But I don't know.
I mean, I'm seeing a lot more flexibility from firms in terms of buy-in for the capital, but I don't know if my experience is different from some of the others on the panel.
I,
Anyone?
in my experience, I do think that I would say roughly half of the firms, maybe a little bit more than half, look for the full amount up front or within like a 30-day period. I don't know if this is a fair correlation, but I do think that some of the firms that have higher capital contributions tend to want that money faster because they're really using it. The partners are functioning, their capital is functioning sort of as a replacement for a bank in a way. And so these firms that are trying to increase profitability, maybe on sort of a little bit of a flat, not necessarily going up as quickly, they tend to want the money sooner than firms that may be more fat and happy and can delay things. So not saying that there's a causation or that a negative inference should be drawn from a firm that wants it right away, but I do think it's a factor to look at when a firm is dead set on having that money within 30 or 60 days versus a firm that's more like, oh, sure, we can, wait a year, or wait till you get it back from the other firm, or once you get it from this firm, your departing firm, we can take it from one pocket and move it over here. The firms that tend to be more flexible, it's one sign of more financial health.
How common is it in your experience for firms to have no buy-in?
Some firms that are corporations have very minimal buy-ins. Some have buy-ins with multiple different ways. For example, they won't take a lump sum up front, but throughout the year they'll have holdbacks of a significant amount, and then so they'll pay you out. So you're earning only 30% of your comp at year end, and then that other 70% comes the following year towards the end. Or some other firms will, yeah. So most firms have some type of, I would say, investment in the firm, but certain firms that are corporate structures arrange it in different ways. And there are a few firms that have no capital contribution. They'll say we don't require capital, and it's a real flex. But that's an exception. And please, others chime in as well.
I was speaking with a candidate this morning that is considering joining a firm that has a pretty significant capital contribution. I think 35%, almost 40% of their first year's compensation as a capital contribution, and they are considering that offer juxtaposed with a firm that has no capital contribution. And to say that it's a small factor would not be correct. I think even when the firm that has the capital contribution is offering a pretty competitive loan, obviously it speaks to the financial health of the firm to be able to say, look, we're going to make you an equity partner. And oh, by the way, we're not going to ask you for any investment in our firm. That's not often the case, but in this case, it is certainly a big part of the decision calculus for the candidate.
Let's move on to the concept or the topic of clawbacks. Slide 38, audience. Brock, give us a quick 101. What should attorneys understand about clawback provisions?
So a clawback is a provision in an offer letter that states that certain amounts of compensation can be clawed back if specific conditions are not met. And those conditions are typically the amount of time that an attorney sticks in their role. So there is a lot of discussion about the concept of guarantee periods and sort of the base share component of a package versus signing bonuses or forgivable loans. So I think that, as far as the clawback discussion goes, certainly when an attorney makes a lateral move, they are typically planning on being successful in their new role, and they're planning on being at that place for the long term. Most of the time, things do work out in our experience, but sometimes they don't. And so it's really critical to be aware of what the specific terms of a clawback provision are. Negotiating clawbacks can be a little bit of kind of a messy thing because you kind of hate to be spending bargaining chips on, hey, what if this doesn't happen, or indicate that you have any sort of hesitancy um, in the potential transaction. So, again, this is a spot where I think it's helpful to kind of lean on ethics counsel and outside advisors to help to push forward the candidate's point of view and to negotiate a period, a guarantee period, and the absence of clawbacks in a way that really makes the candidate feel comfortable that the firm is meeting them halfway and is really taking on some of the risk for the move as well.
Overlay panel.
I was going to say,
Tina.
Go ahead, Tina.
I know, I think Brock's right. And I think another aspect of it is also if you're considering a move, do you have a clawback with regard to any of your compensation at your current firm? Because if you do, then, a discussion should be had on, is there a way to time your move such that you can minimize the negative effects of that clawback? And then another concept to be considered that you should speak to your advisors about is, in addition to talking about minimizing the negative impact, if you can't completely negate the negative effects of that clawback, is there anything you can do with regard to the new firm that you're looking to join to help minimize that? Or maybe completely, fully offset it based on a combination of moving the timing of the notice versus maybe a sign-on bonus or something like that. This is where I see a lot of missed opportunities, in that candidates who are thinking about a move are not familiar with their current agreement, or they just haven't had an opportunity to read their agreement for a while because, oh, I don't know, they were practicing law for their clients. Shocking that they didn't have time to pull out their partnership agreement at night and go through it with a fine-tooth comb. But again, it's sort of the hidden things like clawback provisions that I think you need to be aware of if you're considering a transition, because it can really impact the timing of that, and it can impact your negotiation on the front end and the back end. So something that I would urge everyone, if you're making a checklist as you're watching this of things, of takeaway things to be looking at, this is one of them for your list.
And just one footnote on that is a way to think about this is there's a difference between what you've been paid and what you've actually earned. And a lot of times as recruiters, we think about what someone's earned versus what they've been paid, and they should be made whole based on what they've earned, not what they've been actually paid. But this is the inverse on this, where a departing partner's been actually paid more than they've technically earned on the agreement. And then when they're given notice, their capital contribution is cut off by X thousands of dollars, and they freak out. And because the firm says, well, you didn't actually earn it, it was an advance. And that's where it gets really, really, as Tina's mentioning, really, really sensitive. A lot of people get unhappy.
The other
So
thing,
go ahead.
can I add one thing, Jonathan?
Yeah, go ahead.
And this seems like a no-brainer to say to a panel full of attorneys and an audience presumably full of attorneys, but get everything in writing when you're negotiating these clawbacks. I'm working with an attorney right now that had a forgivable loan paid to them by their firm as a retention effort, and there is some discrepancy about whether or not there was a handshake agreement. But the letter of the contract is very clear that this attorney on departure, if they leave before a certain date, owes the money back. And so, despite what they remember talking to firm management about, firm management has come to them on their way out the door with their hand out saying, "Can we have our money back, please?" So it's important to make sure that all of those discussions, if they do happen, are enumerated in writing.
I just want to follow that up. Alex, you raise an excellent point there. And I know sometimes, and this is for the audience, I know sometimes you think, oh, we've negotiated, this process has taken more time than I thought it would. I really, I don't want to ruffle any feathers. If I bring this up to the firm, it's going to cause a problem. And I want to be, much like you want to be a good leaver, I want to be a good joiner. And I think those are all good sentiments to have. And you should be a good leaver and you should be a good joiner. But Alex raises a critical point. I know, and I will use an anecdote. I had a call from someone recently on a very similar issue. And at the time, we were suggesting we need to formalize this, and it did not happen. And now, the attorney has a very different memory of it than the firm had of it. And this is what happens when you don't put things in writing. So I just wanted to emphasize that Alex is 100% correct on that. And, better to get it set in stone than have to deal with the issue on the way out, because I can guarantee you memories will differ.
My dad, when I went to law school, the first thing my dad told me is the softest writing is more powerful than the loudest yelling. So
Good advice.
So slide 38, that's about clawback. Slide 39 has the word set off, and slide 40 has the words forfeiture provision. Who wants to kind of compare and contrast the three things? I nominate Tina.
You want me to take this one?
Yeah.
Okay. So they are a little bit different, and they're used in different ways. So, for example, a clawback, as Brock eloquently stated, is for money that you've been paid that is clawed back based upon the triggering of some circumstances. A forfeiture provision, on the other hand, is a situation where, let's say, for example, and I'm making this up, but you decide to withdraw from a firm, and the operative agreement states that if you withdraw, and the purpose of the withdrawal is to go compete against that firm, that perhaps certain portions of your compensation in the future will be forfeited, meaning you give up the right to collect those amounts after you leave. But if you were to stay, those are amounts that would be part and parcel of your annual compensation. So that's how a forfeiture provision is a little bit different from a clawback provision. But again, even though they're a little bit different, these are all things that should be on your checklist that you're thinking about when you are considering a move. And I think there was one other one in there, Jonathan, that you mentioned in the interim that has now
Set off.
escaped my mind.
Set off.
Set off. Okay. Set off is a provision that basically says, listen, if you do one of the following things or fail to do one of the following things, and the firm suffers damages as a result, then we can set off or deduct the amount of our damages from your capital account. Let me give you a real world example. Sometimes you will see in partnership agreements where the agreement itself will specifically set forth transition tasks that must be completed before you are released by that firm. So, for example, you may see things such as you need to get all of your time in and entered up to the date of your withdrawal. You need to review draft bills, get those marked up, finalized, signed off, and sent out. you need to work with the firm to continue to collect accounts receivable. And if these things aren't done, then the firm will reserve its right to set off an amount that it feels as though it's been damaged from the return of your capital account. That, in essence, is a set-off provision.
Thank you. And I put up slide 41, audience, financial disincentive provisions. Again, summarizing on the left, what are they? And then on the right, are they enforceable? Tina, how would you summarize maybe we could read the slide, but practically speaking, how do you think about the enforceability of these things?
So financial disincentive provisions have become a bigger and bigger part of my world as ethics counsel, and I am seeing them come to the forefront more and more often than I ever have in the past. It's easy to summarize. The majority rule is that they are not enforceable. The seminal case is Cohen v. Lord Day out of New York. There are cases around the country that follow the Cohen v. Lord Day rule. The states that follow the minority position are coincidentally and very, in my opinion, ironically, California and Pennsylvania. Wisconsin is sort of a mixed bag. It tends to follow the minority rule, upholding these provisions in certain contexts, but not always. But the vast majority of states where they've been tested, they've been held to be unenforceable. So if this is something that you are reading, finding when you're reading through your partnership agreement, all the more reason to have a discussion with your recruiter, perhaps hire counsel to advise you on this because, again, they're becoming a bigger and bigger problem.
Thank you. So I'm tired of talking about money for now, just for the moment. And I'm going to move us to a different topic. Alex, this one will be for you, please. During the interview process, the conflict, search process, what's the rule of thumb for how an attorney who is, being interviewed, maybe being asked to submit information for purposes of conflict running, how should the attorney being recruited handle client information in that context?
I think about the interview process and the conflicts process as being separate, even though they're happening at the same time. For example, during the initial part of an interview process, I always recommend that the candidate talk about their clients in a way that makes them feel comfortable. It's almost like an initial set of dates. Perhaps you're not going to get into all of the heavy conversations. Obviously, if there are really big clients that are significant to them, then perhaps they want to raise them to run an initial conflicts. But generally, I recommend that people speak about them in generalities. And as the two sides and the firms become more comfortable with each other, those names start to come out and those conversations start to become more intense. What I tell people is that they have an obligation, not necessarily to their firm, but to their clients, to make sure that they are being thoughtful about conflicts and they are giving the potential receiving firm enough information to run their conflicts checks to make sure that there are no conflicts that are barring them from joining the firm. And so it's sort of a process that I consider to be a little bit separate. You give them the conflicts information to run the conflicts. During the interviews, you have to do what makes you feel comfortable. And some attorneys are quite comfortable, sharing the names of their big clients. Others, especially in smaller bars, tend to be a little bit more guarded at first because they don't want to give away the secret sauce. So it really just depends.
Tina, isn't the identity of a client itself a confidential piece of information?
It's a great question. And for conflicts purposes, there are ethics opinions out there that are pretty widely adopted, that say for purposes of running conflicts for an attorney that is looking for a new position, they can disclose the names of their clients. That is permitted. But I think that Alex is spot on. And when he uses the dating analogy, I laugh because I use that as well. And I'm a big believer in that, you need to get pretty far down that interview process before you start talking about separate matters for a specific client. I think that you have to disclose them in stages. And I think you also need to be careful in how you disclose them. For example, DC has a bit of a quirky rule in terms of when you disclose, and there first has to be substantial conversations before such disclosures are made. Query as to, what that means in actuality. I suppose we could do a whole session on delving into the definition of substantial conversations. But I think you need to be mindful of what the rules are in your jurisdiction. And I think if you have any questions, it's something that you should be discussing with your advisors in terms of how to do that in a way that makes you comfortable, that gives the firms that you're considering the information they need to run the conflicts check. But I don't think it's something where you go into the first conversation and you do a complete information dump.
I remember hearing as like a kid, real young, young adult maybe, that one should never, not in the context of law, one should never bring up salary in the first interview, bring up compensation. Um, in this cold, hard world we live in with limited time, if buyer and seller are way off the mark, it's a favor to everybody if that's discovered quickly, because otherwise you're wasting each other's time. If someone thinks they deserve, $1 million base and a firm is only prepared to pay $500,000 base, the people in the room could get along beautifully, but there's not going to be a deal. Um, so what is the right time to start talking about, how much business does the potential lateral have? How much money? What's the compensation going to look like? Um, thoughts?
I think it's a really important conversation to have early, especially if you sense or we sense that there might be pretty big separation between what the attorney or the market is for that particular attorney and what the firm is willing to pay for that attorney. And one of the things that I've actually been putting a lot of thought into recently is, most LPQs in every jurisdiction ask about current and past compensation. And I'm curious what Dan and Brock think here, but uh, I'm starting to wonder whether that really matters, or whether it mostly matters what a firm is willing to pay an attorney with a particular book of business and to perform a particular function. And so really the question I think should be to the firm, hey, what do you pay someone like this versus, hey, what does this person make now?
Yeah. It is such an interesting question. And, the comp piece is very much a chess game, or can be on both sides. There are sort of two factors that I see, um, uh, two main factors I see in terms of uh, where an attorney's compensation lands. And typically, where their compensation at their current firm is plays a big part in what the potential destination firm is offering, and then also, of course, what does their practice look like? What are the synergies with the new platform? And in my opinion, I mean, you do see certain cases where somebody's practice is shrinking, or um, they may want to slow down, or there may be a reason why their current compensation is perhaps less important, or less of an anchor. But I really think the discussion has to involve all of that. And um, I'm working with a partner right now who has a significant portable practice. However, a big piece of this practice, there are some questions on whether that particular piece of the practice is portable to a couple of the platforms that this person is visiting with. And so I think it's a really nuanced discussion. And we certainly see people anchoring, wanting a healthy risk premium from their existing compensation to move over. But really, it's a conversation that has to take place really simultaneously with determining what the strategy is and how this person would fit into a destination platform.
Uh, I completely agree. I think the chess metaphor is so apt for this because there's so many different factors that determine, do you bring it up in the first meeting? If it's a peer-to-peer firm and you know that the profits per partner tend to be similar, you can kind of assume, and so much of it is just the context of everything. There are probably 10 to 15 variables that we think about in advising someone when is the right time to think about bringing up the conversation. So I agree, Jonathan, about your point of why don't we just get it out of the way? And if, you know, one partner's making 3.8 and the firm, doesn't want to pay more than 2.7 for similarly situated partners, better to know that sooner, not waste everyone's time. And I think we'd all err on the side of, let's kind of get it out sooner. But so much of what goes into those numbers is hard to determine until they've been further discussions. So it's like everything, a balancing act.
So one
The
of
other,
the way, oh, go ahead.
I was going to comment that one of the things that I think is really important is to rely on your advisors to help set your expectations about what compensation looks like uh, at the firms that you're targeting. And one of the things that's really important, it goes back to some of our discussions from the first webinar, but basically pick someone that knows your business and knows your market, because they'll be able to tell you what a partner like you might make at a firm that you're considering. And that's important because you don't want to target the wrong firms. You need to know your target firm set.
Do you guys think there's a certain market rule of thumb, even if your one's compensation may be stated as um, you know a, a straight draw, a draw with discretionary bonus, non-discretionary. The way that of councils, I think historically have been paid, where it's like a formula, right? Well, for every dollar that you originate and work, you get X percent. For every
Jonathan,
dollar
are
that you
you guys noticing
leverage, you
Jonathan's
can get
camera?
Z%.
Jonathan, just sorry to interrupt. Your connection seems to have dropped a little. Yeah, I would
Yeah,
start that again.
Okay, thanks. Is this better?
Much
Much
better.
much better.
Okay, too much bandwidth.
We
I
may be
take
losing you again.
Uh-oh.
too much space in the camera. So I'll start over.
Jonathan, I don't
no,
think any of us can hear you.
we've
Oh,
lost
no.
you.
Can you hear me now?
We
Yes.
can.
Yes.
Now?
Yes.
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 Okay, if that happens again, please, I appoint you, Tina, as my moderator successor. Are you ready for
Okay.
that?
I will jump in and do it on the fly.
Okay. What I was trying to ask is this. Partner Bob wants to move over to another firm, and the way the compensation is the characterized is one thing. You're going to get a draw, you're going to get a guaranteed bonus, you're going to get a discretionary bonus, you're going to whatever it is. But the end of the day, the way the economics work, I think it's always a function of, three stats. Unless you're coming in, yes, you're coming in as an equity, you're going to get a percentage of the whole, but the underlying that is how much business will you bring in, how many hours will you work, and what's the split of, how much are you gonna work on your own stuff, how much are you gonna work on other stuff, how many people are you gonna feed, your hourly rate. All of these are the sort of at the very basic level. These are the building blocks of what compensation is gonna be. Would you disagree with that or agree with that? Is that a valid way to look at things?
Absolutely. But some firms value some of these things very differently. Some firms will put a lot more weight on your working collections.
Yeah.
For example, what you're billing on, your hourly rate versus uh, your hours on your own time and what you've collected first versus how much work you've originated overall, even though it's performed by other people. So those are the underlying factors. You're absolutely correct. But how certain firms pull those levers and try to incentivize different things can differ. There are certain partners that will have, just say $5 million practice at one firm, and they can earn 2.2 at one firm, where they can earn, 2.6 at another firm, just based on how the firm weighs certain values. So yes, those are the underlying factors, but how they're um, valued can differ by firms.
Yeah. I think it's also helpful sometimes to think about ways that different law firms and different practices are built. All the time you will have folks come and say, like, what are the rules of thumb for compensation? Uh, Generally, I think you've got, as Dan sort of mentioned, there are some partners who have practices where they have what we would call a book of business, and the practice is built around their relationships with clients, and they're bringing revenues into the firm that themselves and teams um, within their practice area or across practice areas. All of those people will come in and help to service these clients. And so, you'll hear a lot of times this is a super broad, um, this is kind of a very broad look at this, but partners on their book of business, the market is somewhere in like 25 to 40% of their book, what they could expect in their annual compensation. That's very rough. Um, I've seen it go higher, I've seen it go lower. Um, Also, at a lot of firms, there are attorneys who have very important esoteric practices that are highly important to particular clients, individual clients, or types of clients. These in the corporate space, we call these specialists, tax lawyers, executive comp, regulatory lawyers, all different types of specialist practices that support corporate folks. And oftentimes you will see economics for specialists in highly coveted practices that can sort of defy some of the traditional rules in terms of books of business and things like that. So, I've seen specialists and tax specialists who have a particular area of expertise that only a few people in the world have. Particularly when these specialists are supporting the private equity industry. You can find folks in these specialist practices whose comp packages just totally defy the typical norms. So I do think it's important to kind of think about their business originators, and then there are folks who have very special and important skill sets to service big clients at large law firms.
I want to piggyback off Brock for a moment. I'm DC based and spend a lot of time working with regulatory specialists in really two main niche areas of the law. And in some cases, when you really drill down, there might only be 5 or 6 people in the country that do what some of these attorneys do. And Brock's exactly right. I mean, there can be a tremendous premium on these types of capabilities, especially when they're in the M&A space or surrounding a private equity practice. And there's such competition in terms of building out corporate practice groups these days that having one of these specialists can be the difference maker in winning a deal or not winning a deal and bringing a large transaction to the firm. And one of the things that you should pay attention to if you're one of these specialists is how many other people are there like you. And that's a conversation that you should have with your recruiter, because it's really helpful for me to say, I don't like to use sports analogies, but if anyone who knows anything about fantasy football, it's draft season, and you want to draft running backs because there just aren't a lot of them in the National Football League, and they tend to get hurt. Whenever I'm working with a running back, I make it known to a firm, hey, this is someone that has capabilities that are not widely possessed. And so that can certainly influence compensation.
Let me stop this piece of the conversation here, and slightly move us on. I'll segue. I can do that. So, in the context of the lateral partner questionnaire, what are some of the different ways firms will ask about portable business, and why is it important to understand this? And before you can answer that question, although it's not the first time we've uttered the term LPQ in this webinar, I don't think we've ever took the time to really, I think it's probably stating the obvious, but paint a picture of the LPQ, please. Brock, you take this one.
Okay, well, the LPQ is probably
Slide
every
20,
candidate's
by the way,
least.
audience, slide 20 and 21.
Sorry, say again, Jonathan.
I'm sorry, slide 20 and 21 for the audience.
The LPQ is probably every candidate's and every recruiter's least favorite part of the process. These are essentially diligence forms that a law firm will use to underwrite a practice. And so broadly, they'll ask for, basic biographical information, a write-up on your practice. Sometimes they'll ask you to attach a business plan, which can be helpful in some cases. And then they will typically ask you for your last 2 to 3 years of financials with respect to your clients and revenues, as well as your compensation. And then they often will also, as an attachment, have the conflicts form attached, which can be completed sort of concurrently or later, depending on the process. But it really is, from a firm's perspective, it is kind of the main source of information that can be circulated among the hiring committee and the folks who are determining, is this person or is this group the right fit for our practice? And what do we think the potential upside is? What are the potential risks? And how do we determine what to pay this individual or this group of individuals?
Overlay?
So
pretty
I just want
comprehensive.
to jump in and add one point with regard to the LPQ. Each firm has their own version of an LPQ. And you've probably heard me reference this in episode 1, but the terminology can vary. And I think it's very important that if you're an attorney considering a move, this is one of the reasons why having a great recruiter is so important, because the good recruiters know how each firm operates. They understand how these firms underwrite the candidate. I mean, let's just be very frank. That's what happens. It's an underwriting process to set the compensation. They know how the firm set the compensation, and therefore they can assist an attorney that's considering a move. You know, if there's a defined term in there, or maybe it's not defined, a recruiter can say to you, or an advisor can say to you, this is what the LPQ means, which is very important, because I've seen situations where it's been like two ships passing in the night. The person completing the LPQ thought that the firm was asking for this type of information, and the firm was really asking for this type of information. And you don't want that to happen, because believe me, when the firm is doing its due diligence, if you are not giving it the information it is requesting, it can vastly change the outputs from all of those metrics that are being considered. It can have a significant impact on those calculations, and as a result, the comp that is offered. So I think it's critical to make sure, and Brock's right, it is definitely, I think, as a candidate, their least favorite part of the process, but it is a very important part of the process. And so anyone considering a move should speak to your advisors about this and make sure that you're giving the information that is actually being asked of you and not something else.
If I can overlay one other thing here, one of the biggest mistakes partners use is their frame of reference in terms of what other people have done when they've come to their own firms. They use that as a basis on which they should make their own projections. For example, I've heard so many partners say, I know how we discount books of business. If someone comes to us, we assume it's going to be 30% less than what it is. So I'm going to kind of assume that the next firm does the same thing. So I'm going to increase it, assuming that and we're like, no, 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 no. Do not get in the game of trying to game or figure out what the discounts are going to be. The best thing partners can do is two things. One, be very honest on what your projections are, even to say, I don't know. I don't know is sometimes the best thing you can say on an LPQ, or you can say, it's better for us to discuss this because there are a number of other factors that are going to go into how I were to assign this a number. And the second thing to do is add parentheticals, footnotes, explanations, context. Imagine they came to you in person and said, what is the answer to this? You wouldn't just say, give a number. You'd say, well, it depends. Assuming this, assuming you have this type of practice that can support this, it could be this on the low end or this on the high end. And a lot of LPQs are written so poorly, they don't give you enough context to be able to explain what sometimes may require several sentences or a paragraph to correctly answer about one client. So don't use the form as a straitjacket when you're answering the questions. Be very willing to add parentheticals so that you're communicating what you need to communicate, even if the box is only one line longer. You know, keep adding more information. They'll appreciate it and they won't think poorly of that.
I cannot recall submitting an LPQ without attached pages ever. Because every LPQ, I don't care which firm it comes from, it is meant to be standard, and no practice is cookie cutter. Everyone is special, and I don't mean that in jest. I mean, there are unique pieces to every practice that need to be fleshed out for decision makers to understand, because what you have to assume is that the people reading the LPQ are not in your area of specialization. You might be a litigator and they might be a corporate lawyer, or they might be a tax lawyer. And so it's important for you to explain in as much detail as possible the details of your practice.
I think one last thing that I feel like I'd be remiss if I didn't say about the LPQ. I see it is, I think you cannot overstate how time consuming these things can be, particularly when there are multiple processes involved. And Tina, as you said, firms have a way of asking for very, very similar information, but asking for information that's just different enough to where it requires significant duplicative efforts. I'm certainly a huge fan, especially if you're considering multiple processes of working with an advisor on the recruiting side and on the ethics counsel side to do that. Um, Firms are watching you. From a candidate's perspective, firms are watching you and they're watching your body language sort of throughout these processes. Candidates are watching firms' body language as well, of course. But one of the biggest things where I see firms lose interest in a candidate is if they take forever to get the LPQ done, and that just can kill a process. I've really seen it time and time again. I think that, and I'd be curious, Dan and Alex, to hear what you guys think is a reasonable time frame, sort of understanding people have a lot going on. I think that you should try to get an LPQ completed and back to a firm within 2 weeks. I have seen people go 6 weeks or longer, and it just is always destructive to the process.
I agree with 2 weeks, but what I will sometimes say is let's get maybe just the financial section done because that's the most important. And then if we need to come back to, obviously the due diligence questionnaire is pretty easy. What's often most time consuming is going back to 3 years or sometimes 5 years of adverse matters. So we'll say, let's just finish this part, get that back to them, and then we can give them a list of who the clients are to run an initial conflicts check. But we're not going to fill out that whole conflicts form until later in the process. But I agree. I think 2 weeks is like an ideal time to aim for. And the most important thing is if you need time, don't just avoid letting the firm or your recruiter know, say, I've been swamped, I'm busy. Let them know I haven't forgotten about this, but it's still a priority for me as soon as I can turn to it.
I turned us to slide 46, firm notice periods. Generally speaking, who should receive notice of the departure first, clients or your current firm?
That's an easy one.
Mm-hmm.
Your current firm should receive notice first. Okay, for all of those who may be listening that fell asleep, this is where you need to wake up because this is the golden rule that should not be violated. Generally speaking, and there's an exception to every rule that we'll get to in a second, but generally speaking, notice to your current firm always happens first, unless there are exigent circumstances. And exigent circumstances mean the following, and it is a narrow exception to the rule. It is not an exception that swallows the rule. So, for example, if you are a litigator, and you are about to give notice to your current firm, let's say it's Friday, and you're going to give notice the following Monday, and guess what happens? You get hit with a motion for a temporary restraining order. That is a situation in which you should speak to your ethics advisor, but chances are that is going to fall within an exigent circumstance. And under that circumstance, you may need to apprise the client about the fact that you are intending to give notice because it could impact the client's interests. But again, I'm going to repeat this a third time. So everyone has this as a takeaway. You give notice to your current firm first before the clients.
That is one of the main sticking points, that when people give notice, the firm will say, have you told any of your clients? And that can open up a whole can of worms if the answer is not no, or there's also the issue with references, but agree completely and resist the temptation, other than speaking to your client in hypotheticals about if I were to move, if I were to consider moving, things like that, to kind of gently get around it. It's gotten really ugly when that happens.
That's a good place to end this episode.
He's going to leave everyone hanging.
It just gets uglier and uglier.
We'll be back again soon, ladies and gentlemen, but that is the, we are out of time. So.
Thank you, everyone. Thank you,
Panel,
Jonathan.
thank you.
So
Thank you, everyone.
Bye.